Welcome back to Organized, the business law breakdown. I'm Professor Seth C. Oranburg, and today we are on episode 2 of our season on corporations. We're getting into the legal birth certificate and operating manual of a corporation, the corporate charter, and its bylaws, or sometimes the charter is a blanket term that refers specifically to the certificate of incorporation, that's the birth certificate, and the bylaws, the operating manual. The certificate of incorporation and the bylaws don't just lay out how a company functions, they also shape who's in charge, who gets what, and what happens when things go sideways. One point about nomenclature before I continue. In Delaware, it's called a certificate of incorporation. Under the Model Business Corporations Act, it's a certificate of formation. They're the same thing. Collectively, they are charter. If corporations are legal persons, these documents make up their DNA. And just like in biology, bad DNA leads to bad outcomes. Corporate disputes, governance failures, and even lawsuits that shake up entire industries. And this is worth pointing out for lawyers because they tend to cut and paste bylaws from things they find on the internet, thinking that they're not important. And just like everything in contract law, it's not important until it is. And it's malpractice to ignore these sort of things. So, what are these documents? What do they do? Where do things go wrong? Let's get into it. The corporate charter, which some people will use to refer to both documents, but I use as a synonym for the certificate of incorporation or the certificate of formation because different states call it different things. It's easier to just call it the charter. The charter is the document that creates the corporation. It's filed with the Secretary of State in whatever state the corporation chooses to incorporate in. Delaware, California, New York, North Dakota. You can pick any state in America and form there regardless of where you're located. And so there's some competition to get companies to incorporate in one state because then you can collect some taxes. So what's in a corporate charter? They're actually very simple requirements and they get very long when you have complicated ownership structures like in venture capital. But at a minimum, every charter must include the corporate name. Can't be the corporation, that's too vague. Can't be McDonald's 2.0. The trademark lawyers will get you. And it has to include certain suffixes like Inc. or company or corporation that make it clear to outsiders that you're dealing with a corporation. It has to have a business purpose, but it actually can be any lawful activity. Some corporations will state a specific purpose, especially if they're a nonprofit corporation, a form that we will only touch on briefly. But a nonprofit corporation does need to specify its nonprofit activity so it qualifies for tax-exempt status. Most corporations simply say they engage in any lawful activity. In fact, if you go to Delaware and you download a copy of their form of certificate of incorporation, business purpose is already filled in. It's not even an area that you can change on the form because why would you? It only creates liability through what's called the ultra vires doctrine, which we can discuss later. The third thing is the stock structure. This is a big one because a company is owned through shares of stock. Shares are literally that, like percentages of the company. So if you have 100 shares and you give 1 to Sally, Sally owns 1% of that company. So it's really important how many shares exist because if you have 1 of 100 shares, you have a lot more than if you have 1 of 5 million shares. So the charter will specify how many shares exist. That's called the authorized stock. There's also different types of stock. Common stock is, well, common. It has very few features, very few bells and whistles, other than certain rights to vote as a default, although those can be waived or changed. And then we have preferred stock, a more complicated concept that incorporates some preferences and has some debt-like elements, like receiving dividends. There are voting rights attached to each type, and there can be multiple classes. It can get super complicated. The key thing is you do need to specify that there's at least 1 share of stock because somebody has to own a company. That somebody could be another corporation, by the way, but you need to have at least 1 share and someone has to own it. You also need to have a board of directors. Every corporation shall be governed by a board of directors, and you must have at least 1 director. The initial directors can be named here. They can also be selected later. You don't have to name them, but you have to specify how big is the board, and the minimum size is 1. So we have a minimum of 1 stock, 1 owner, a minimum of 1 director. They can be the same person, but as we'll see in a moment, the point of corporations is often that they are not. And finally, you need to specify the registered agent because you have to provide public notice of how to sue the company. And the registered agent is the official recipient of lawsuits and legal notice. This is all, by the way, in Delaware General Corporation Law, Section 102, and Model Business Corporations Act, Section 2.02. The requirements are very similar no matter where you go, and it really is that simple. Corporate name, business purpose, which is often any lawful purpose, stock structure, board of directors, and registered agent. Sounds easy. So what could possibly go wrong? Well, there are several problems that can come up and result in a defective incorporation. We all know that lawyers never make mistakes, but if they did, they might file the certificate of incorporation wrong. For example, you might file it with the wrong state. Oops, doesn't work if it doesn't have the right state on it. Or maybe the filing fee isn't paid or fully paid because you looked up what it was 5 years ago and it's been increased. Maybe the incorporators just forgot to file it at all. Or in one case, they handed it to their lawyer who left it in the file cabinet. But, what's a legal technicality between friends? Well, here's the problem. That limited liability I mentioned last episode doesn't apply if there's no corporation. And there's no corporation if it isn't actually formed, since it's formed by an act of the state. Until the Secretary of State stamps on that certificate of formation, that birth certificate isn't valid, the corporation doesn't exist, and you don't get limited liability. You also don't get perpetual existence and the neat separation of ownership and control that makes corporations so powerful. So there's all kinds of other issues, including what happens to all the intellectual property that's generated between when this is begun and when this gets fixed. But in corporate law, we're going to focus on the problem of this defective incorporation. So what happened? Well, as we learned in our season on partnership, you probably have a general partnership or a sole proprietorship, depending on whether there's 2 or more persons who carry on a business for profit. If there's just one person, it can't be a partnership. But if you're in a general partnership, suddenly you've got personal liability for your partner's debts and torts that are carried out in furtherance of the business obligations. And your business credit card? Yeah, that's just your credit card. So, problem. But courts aren't completely heartless about this. If a company operates like a corporation but wasn't properly incorporated, there are 2 doctrinal lifelines. And these are worth noting if you're going to take the bar exam, because the bar examiners like to test on it. They're called de facto corporation and corporation by estoppel. A de facto corporation is when the business made a good faith effort to incorporate, but something unusual went wrong. Courts may still recognize it as a corporation to protect the shareholders. And this happened in Southern Gulf Marine Company versus Camcraft, a Fifth Circuit case from 1985. A company thought it had incorporated. It did business as a corporation. It even held itself out as one. You can imagine it had ink on its business cards. The court ruled that even though it hadn't filed correctly, it was a de facto corporation because it had acted like one in good faith. The second doctrine is corporation by estoppel. Estoppel is a doctrine of claim preclusion, basically saying you can't claim I'm not entitled to limited liability because what is that other parties treated it as a corporation. So if you treat me like a corporation, you can't later claim that I'm not entitled to limited liability because of a formation error. This happened in Cranston versus IBM back in 1964 in Maryland. Cranston invested in a business that he thought was a valid corporation, and IBM tried to hold him personally liable for its debts, which would be valid if it were a partnership, but limited liability would protect him. The corporation didn't technically exist, but IBM had treated itself as dealing with a corporation, not as dealing with Cranston as an individual. And since IBM had acted like it was dealing with a corporation, it couldn't suddenly change its mind. It was stopped, precluded from claiming that Cranston was personally liable. Now, these aren't fun, and I don't recommend relying on these doctrines. The moral of the story is just file the paperwork correctly. As I mentioned, it's pretty simple. If you don't, you can hope a court thinks at least you tried. The other issue that comes up is when you say something other than any lawful purpose for your business purpose. And there are reasons to do this, like limiting the scope of authority that the managers and officers have, and Potentially this is necessary to get nonprofit status. But again, most for-profit corporations will say any lawful purpose. So this doctrine is a little bit dated. It's called the ultra vires doctrine. When the certificate of incorporation defines what the company is legally allowed to do and the corporation does something beyond it, what then? So this came up again more historically. Corporate charters used to contain pretty narrow purpose clauses. So a company would be chartered to build railroads or produce cars. And if it strayed too far from the purpose, shareholders could sue under the ultra vires doctrine, meaning beyond the powers of the corporation. Just a little historical note on this that I think makes this interesting is that the ability to create a corporation simply by filing paperwork is a relatively new invention, and it's an American invention. I've actually argued in my scholarship that America is the industrial powerhouse it is because of this innovation of free incorporation. Before that, you actually had to go to Congress and you had to ask permission to incorporate. And before this, the Crown. And the Crown would grant these monopolies on trade only to certain people that it deemed worthy and for only narrow purposes so it could control the marketplace. In any event, this doctrine came up more in the past and on bar exams. Let me give you an example from good old 1875. In Ashbury Railway Carriage and Iron Company versus Riche, if that's pronounced right, or Rich, a British company had a charter allowing it to manufacture railway cars. And just to manufacture railway cars, it tried to finance a railway construction project instead. That's not manufacturing, it's financing. When the deal fell apart, the other side sued, and the court ruled that the shareholders were not protected because their action was void, because it was ultra vires. It was outside the corporation's designated powers. To state one more time, today, ultra vires arguments are rare because most corporate charters just say the corporation can engage in any lawful business activity. So it only becomes ultra vires if it's illegal. But this still comes up in disputes over corporate social responsibility and shareholder activism and nonprofits, and it's still potentially relevant. If a company's charter says it exists to maximize shareholder value, and the board suddenly decides to send millions on social causes, could shareholders sue to stop it? Maybe. Or a corporation that certifies itself as a benefit corporation and puts in its charter that it limits its profit in order to seek a social benefit. Does that give room for a lawsuit? Maybe. Courts tend to give boards a lot of business judgment discretion, but the ultra vires challenges can lurk in the background when they choose to tie their own hands. All right, so you filed your certificate of incorporation, or in an MECA jurisdiction, your certificate of formation, whatever. You filed your charter. The state stamped it. Secretary of State said, you're a company. Great. Now what? Well, that's your birth certificate. Doesn't tell you how the company runs. That's where the bylaws come in. Bylaws are the rule book for how a company operates, and they govern everything from who's in charge to how votes happen to what to do when there's a tie. They're adopted by the board of directors at the company's first meeting, often in what's called the organizational resolutions, and they can be amended later if needed through certain procedures. What's in them? Well, the board of directors, its structure and its power will be in every corporate bylaws worth its salt. It'll say who's on the board. How long do they serve? What happens if a director resigns? And importantly, can the board meet virtually? We'll talk about this in our season on corporate governance, but it used to be the case that you had to meet in person, and some states still require that. Then this thing called COVID happened, and a lot of boards needed to meet online, and some states changed their law. So now, generally, online meetings are permitted, certainly with regards to Delaware. The thing is that the boards do have to meet in order to have any power. A director has no power individually. Their directors only have power as directors, qua directors, meaning when they sit in a meeting as a board. Yeah, it's really cool. You're the chairman of the board, but you can't go and have the company buy gum without permission. You don't have any authority to do that. The board has the power to run the corporation, and it says so in Delaware General Corporation Law Section 141. Corporate power is vested in the board of directors. And again, it's a reminder of that separation of ownership and control that will keep coming up as a feature and not a bug. Shareholders don't run the day-to-day. The board does. In fact, they tend to take that power and give it to executives like the CEO, who gives it to assistants and down the chain and down the chain. The bylaws spell out how this operates, operates at the highest level. It also talks about how the shareholders meet, because the shareholders do need to meet. Under Delaware General Corporation Law, they must meet at least once per year. That's section 211. The minimum number of shareholders is specified by what's called the quorum. The default is a majority of voting shares, which is not a majority of people. There's another distinction between corporations and partnerships. In a partnership, one person, one vote. In a corporation, one share, one vote. You could have one person with 2 shares and another with 1. And that means that only one person has to show up in order for a quorum to be met. In a corporation that small, you may amend the bylaws to make sure that every voice is heard at the shareholder meeting. So the bylaws need to speak to these sort of things like shareholder meetings and voting rules. It'll also talk about whether shareholders can vote by proxy without actually coming to the meeting. And that's allowed under Delaware General Corporation Law, section 212. And later, we'll talk about proxy battles. A lot of corporate bylaws let the board set meeting rules as well. So the board can choose to have virtual meetings or not, can choose to adopt Robert's Rules of Order or not. Robert's Rules is pretty complicated for a small organization. So anyway, the shareholders can decide how they're going to run their meetings through their bylaws. The other thing it'll set up is the officer roles and responsibilities. So we'll have some titles, and you can make them up. You could have Grand Poobah. More traditional would be CEO or President or CFO, sometimes Treasurer and Secretary. It'll mention the roles that have to be filled and talk about their job description. What do they do exactly? And how do they get appointed in that role? Does the board appoint them? Do the shareholders elect them? Less common. Bylaws typically have to specify at least 3 offices: president, a secretary, and a treasurer. Beyond that, titles can be whatever the company wants. So you can call the CEO the chief visionary guru guy. That's fine, so long as the bylaws say so and it has the role that a president would play. Or the scrivener could be a fun name for a secretary. Once again, it doesn't matter what you call it, but you do need to have those roles. Things do get weird if you try to go to a bank and get a loan and you mention that you're the scrivener, so it's typically advised to just go with the standard playbook. Finally, the bylaws will talk about amendments and emergency powers. The board can amend the bylaws, but what's the process for doing so? Do the shareholders have to approve the changes? What kind of changes? Delaware General Corporation Law sets the outer limits of this in section 109. And if there's an emergency, like if a bunch of directors quit at once, or if the company faces a crisis, how do you call an emergency meeting? Or can the remaining board members act alone, or does the power devolve to the shareholders? So bylaws contain emergency provisions for these situations. Bylaws are actually pretty complicated. They're long and they're boring because they're not like a story that makes any sense. It's not even as good as reading corporate case law, which is my favorite thing to do at night. If you really want to go to sleep, read some bylaws. They're like a reference manual. It'd be worse than picking up a dictionary and just starting at B and going forward. But you do have to read them and review them to think about all the contingencies that can happen over the course of the unlimited perpetual life of a company. There are a few things that happen all the time, a few fights that come up. And so you hire a good corporate lawyer who's going to make you sit in a room and talk about these things, like who gets to call a special meeting. In 2020, a major shareholder fight erupted at Occidental Petroleum Company because activists wanted a special meeting to replace the board, and the board refused. They cited their own bylaws, and so they win. There is also the poison pill defenses. How able is the company able to block hostile takeovers? And that only comes up when it comes up, but it sure is important when it does, because boards often want to stay entrenched and don't want to sell the company to a hostile force that's trying to buy up all the shares. And the shareholders, at least some of them, certainly the ones who tender their shares, who offer to engage in this activity, are now at odds with the directors. So in Airgas versus Air Products and Chemicals, a Delaware case from 2011, Airgas's board used its bylaws to delay a hostile takeover by tweaking how long directors served. The Delaware court said it's fine because the bylaws gave them power to do it. But there are other cases where the board acted in a way that entrenched its own interests by modifying the bylaws and was found liable. These were invalid transactions. Has to do with the duty of loyalty, which we'll come to when we talk about shareholder litigation, and as I keep mentioning, corporate governance. What if the bylaws conflict with the certificate of incorporation? Well, they do talk about different things, but poorly drafted ones could have a conflict, and if there's a conflict, the certificate of incorporation, or the certificate of formation, wins. Delaware courts view the charter as more fundamental. The bylaws are subsidiary to it. So it's kind of like in American law, the Constitution ranks supreme over any federal statute. Likewise, the bylaws, which can be very extensive, are going to be like statutes, and the certificate of incorporation like the Constitution. It just outranks it. So bylaws may sound, and in fact are, boring to read. They're not interesting narratives. But when you learn the sagas that happen when conflicts occur over these bylaws, you realize how they shape how corporations function and how they can shuffle around billions of dollars. They decide who's in charge, how votes work, and what happens in a crisis. And here's the kicker, you don't even have to file them. The companies can tweak their bylaws quietly, and sometimes this blindsides shareholders in ways that is meaningfully disempowering. And so there's some case law on the extent to which the board can do this sort of thing. So the next time you hear about a boardroom power struggle, take a look at the bylaws. They're often the rules that define the battle, the rules of engagement. So let's sum it up. A corporation legally exists when the certificate of incorporation is filed and stamped with the Secretary of State in the state of its choice. And that becomes the company's birth certificate. It creates the entity, it gives it a name, sets up its initial stock structure, and it lays out its purpose, or says any lawful activity, if you don't want to overthink it. It can be amended, by the way, and the way that you amend it and run the corporation is going to govern how the corporation functions going forward. One of the key governing documents, the rules for running the corporation on the day-to-day and the annual basis, are the bylaws. The bylaws set the ground rules for directors, officers, and shareholders, defines who has the power, who has the shots, how decisions get made. In our next episode, we're going to talk about corporate finance, how to raise money by selling stock or issuing debt. And so this idea that the charter is going to specify how many shares are available is going to become even more relevant as we step into the next episode. But for now, I'm Professor Seth C. Oranburg. Thank you for joining me on this discussion of incorporation and bylaws.